There's a principle that sits at the very core of American law, and it's this: the Constitution comes first. And this isn't some new, hot-take idea. It's a legal doctrine that's been settled for over 230 years. So let's ask a really basic question, but one that gets to the heart of everything. What happens when a law, or a regulation, or some government order goes against the ultimate law of the land, the Constitution itself?
Okay, before we dive any deeper, I want to make one thing super clear. What we're talking about today isn't about politics, or parties, or personal opinions. This is about established, black-letter law, the kind that courts have been using for centuries.
To really get a handle on this, we first have to understand a crucial difference: the difference between a legal doctrine and a political ideology. And trust me, they are not the same thing.
So take a look at this. On the left, we have constitutional doctrine. These are binding legal rules. They're taught in every law school, and they're what govern how our courts actually work. Now, on the right, you've got political ideology. That's all about beliefs, opinions, or theories. It's subjective, and here's the key: it is not legally binding. For this whole explainer, we are living firmly in that left column.
All right, so where did this binding rule even come from? It wasn't just pulled out of a hat, right? To find out, we have to go back to the foundational principle of the entire American legal system.
And that principle is called constitutional supremacy. It's a simple but really powerful idea. The Constitution is the highest law in the land. And because it's supreme, every other law, rule, or government action, doesn't matter if it's a huge federal law or a tiny local rule, it has to conform to the Constitution. If it doesn't, it's just not a valid law, period.
And get this wasn't some newfangled idea invented later on. As early as the 1790s, right after the country was founded, American courts were already working this way. That famous Supreme Court case, Marbury versus Madison from 1803, it didn't create this idea. It just officially confirmed what everyone in the legal world already understood to be true.
But here's the really wild part: just how consistently this principle has been applied over the centuries. It is truly an unbroken rule. I mean, just think about the most turbulent, game-changing periods in American history. The chaos of the early Republic, the trauma of the Civil War, the massive government expansion during the New Deal, and all the way up to today. Through all that upheaval, the Supreme Court has held on to this one steady rule.
And you don't have to take my word for it. The Supreme Court itself said it in the clearest way possible. An unconstitutional act is legally inoperative as if it had never been passed. Just let that sink in. It's not just that the law is wrong, it's like it never even existed in the first place.
So what does that actually mean in the real world? Well, it's pretty straightforward. If an act is unconstitutional, it can't give anyone any rights. It can't force anyone to do anything. And it creates zero lawful obligation for anyone to enforce it. It's legally a ghost. It's void. Okay, so this isn't just some dusty legal theory for judges and lawyers, right? This is where the rubber meets the road for every single public official. It all comes down to their oath of office, which isn't just a ceremony, it's a binding duty. And when I say every public official, I mean everybody. From the President of the United States all the way down to a local school board member. They all take an oath, and that oath is to do one thing: support the Constitution.
So think about what that oath really means. The loyalty is directed to the Constitution. The oath is not to a government agency or a particular policy you like, or even to the person who is your boss. The number one allegiance is to the document that sets the rules for the entire game.
Yeah, so that oath, it's not just for show. Legally speaking, it creates what's called a fiduciary duty. That's a serious legal and ethical responsibility to act in someone else's best interest. For a public official, their duty is to act in the best interest of the Constitution. And that means it requires real judgment, not just blindly following orders.
Okay, so we've been talking about a 230-year-old rule. You might be thinking, why should I care about this now? Well, it's because this old idea is actually more relevant than ever when you look at how modern government works.
You see this pattern happen all the time. First, a vague law gets passed. Then, government agencies come in and write hundreds, sometimes thousands of pages of really detailed rules. And then finally, informal guidance from those agencies starts getting treated like it's actual binding law. Power can kind of drift away. And that whole process, that power drift, that's precisely why this doctrine of supremacy is so important. The Constitution is supposed to be the hard boundary, the ultimate line in the sand.
When any part of the government crosses that line, whatever they did becomes void.
So here's the bottom line, especially for officials working at the state and local levels. Making sure government actions follow the Constitution, that isn't defiance. That is the very definition of lawful governance. It's doing the job you swore an oath to do.
So let's just bring it all home. The principle that an unconstitutional law is no law at all. That is not an opinion.
And it is not a political ideology.
It is over 230 years of consistent, unbroken, rock-solid Supreme Court doctrine. It's the very bedrock of the American legal system.
Which, leaves us all with one final question to think about. If doing things by the book, by the Constitution, is what lawful governance is all about, what does that really require from our public officials and from us?
Because at the end of the day, after all the arguments are over, the settled law of the land is actually crystal clear. The Constitution comes first.